Welcome back. We have yet another perspective. Mr. Ifedayo Adedipe, who was conferred with the rank of Senior Advocate of Nigeria (SAN) in 2005, has a front row seat in some high-profile corruption trials as a defense counsel. He believes there is no justification for the release of a looters list.
There is a presumption of innocence under a constitutional arrangement that anybody who is accused of any crime is presumed innocent, and that if you have to prove the charge or charges, you have to do so beyond reasonable doubts. Now, when the federal government releases a list and tags it the list of looters, implicit in that is that the government itself has concluded without judicial pronouncement that such individuals are guilty of the allegations leveled against them, in violation of the principle of the Constitution that presumes people innocent. I think that is wrong. It should always be borne in mind that what we operate is a constitutional democracy, and that under this arrangement, the government itself came into office by election and swore to oath of office to observe and to be bound by the provisions of the Constitution. So what this list has done, what the release of this list has done, is that the government is only paying lip service to the oath of office it took when it came into office, and that the government official releasing the so-called list of looters is either not mindful of what the position of the law is, or is disdainful of the law. But above all, I think we are allowing politics to trump our sense of decency and justice. When you call somebody a looter who has not been so adjudged by court, he is not the only victim of that slander, if I could use that word. The family members, the children, the spouse will be adversely affected by such claim. I think it's very unfair, and I think I expect a higher standard of behavior from a government that has about 7 lawyers in the cabinet. I think the so-called list of looters, if you look at it again, is so tilted that you ask yourself, can this really be the only list of people that stole us blind? You clearly find a situation in which the former National Security Advisor had been accused of looting $2.1 billion, I should think. You put his name. Then everybody whom he gave money, you include. And anybody those people gave money to, you include. So that the impression you get is that, oh, they've looted several billions many times over. I think that is not too good, if you ask me.
You've also talked about the shortcomings of the prosecution, shoddy investigations by the police, poor prosecution. And I'm wondering, a lot of Nigerians are curious to see acquittals or convictions, as the case may be. What do you think is responsible for the long delays that we see, especially with these high-profile corruption cases? Because you're involved in some of them.
I believe that we need to take a second look at our investigations, at our prosecution, and our mindset. A prosecutor does not have to persecute. His duty is to present facts of his case, whether favorable or not. And it is for the court to sift the chaff from the grain and come to a conclusion. Now, when a trial court discharges, it could be that an individual's case is not proved beyond reasonable doubt, rather allow 9 guilty to go down for an innocent to suffer. That is the principle. And the basis is that the state is presumed to have all the necessary arsenal to make a case against an individual who alone needs to defend himself. So the state is saddled with the responsibility of proving the case against an individual beyond reasonable doubt. Now, if the state fails in that duty, you cannot blame the courts for not convicting because the public is baying for blood. So I think our own mindset too has to do with the perception out there. Judges do not produce evidence. Judges do not add to the provisions of the law.
But ultimately, you think that what will help our system is when there's a buy-in of everybody, even government officials, into this anti-corruption.
Wrongdoing by the government is a disincentive for people to believe in the policies and philosophy of government. If you want people to support you, you walk the talk. It will be a hard sell for this government to justify some of the horrendous misconduct of its officials that it has glozed over. I just mentioned to the other time. How about the minor gate? A man was dismissed. He left this country mysteriously. The Honorable Attorney General of the Federation met him. The DSS sanctioned the meeting. The NSA was probably at such meeting. And you smuggle the same man in, and then he disappears again. How do you tell people you are serious? Somebody, an executive secretary, was found indicted, shall we use that word, by his minister. The next thing, you recall him. I am still surprised that that minister is still sitting. He should have resigned out of respect for his own self-dignity and worth. Now, how will he give that man directives? How will he correct him? Because the man is probably superior to him now. You have a secretary to the government who should be at the forefront of the policy. Is indicted. Is there. The NIA scandal. You are getting nothing.
But in all of this, it appears that you've left out your constituency, the Defense Council, because a lot of people say that the law in Nigeria is on trial when big people are on trial. Are you absolving the Defense Council of any blame?
Now let me talk about defense attorney. A defense attorney is to defend. It's not to make the case for the prosecution. And if the prosecutor is not up to his task, so be it. As a defense attorney, you are not to suppress facts that might probably lead to a conviction. You are not to, but we have a duty, statutory duty, not to disclose confidential matters. So, if a defendant says, I probably think I'm guilty, what do you think? It is not for the lawyer to say, okay, I'll tell the judge you are guilty. Let them prove their case, first of all. And when it comes to technicalities, we need to be careful what we say here. Technicality is part of the law. I recall that about the time of the last election, the party in power was very vociferous about now president, and they wanted to go to court. The counsel to the current president raised technical points, and there you are. So it is part of the professionally permissible tactics to ensure that you, I've said it, to defend. Yours is to defend, not to manufacture. And remember, the principle of proof beyond reasonable doubt is founded on the legal belief that the state has all the resources at its behest to find whatever it needs to find to make a case. Police, the army, SSS, NIA, etc., including agent provocateur to make a case against an individual. And then, how about lawyers? The government can afford to pay for the best lawyers. Now, a single individual is ranged against such a leviathan. So, if there is a technical point to spring him, why not? It is permissible. So, there's nothing the defense lawyers have done that I will condemn. Of course, there are some lawyers who are, shall I say, not too professional. Asking for one adjournment over another, after another, is not even giving the profession a good image. But majority of the fault is with the prosecutor. If you bring your facts, I should have to think that a judge will over them. Because remember, a trial court will need to have its record examined by the appellate court, and the appellate court will have its own record examined by the Supreme Court. And these things will appear in the law reports. I remember reading where a judge was condemned as given the fraudulent judgment, standing the law on its head. Such harsh words should make any judge worth his salt to sit up and ensure that substantial justice is done.
That's the program for today. What do you think? Please feel free to also share your views with us via any of our social media handles. You can also watch this episode of the program or past ones on our YouTube channel. I am Shola Sheyeli. Thank you for watching.